Hi. Brokers know that the Division of Real Estate has a form of the contract to buy and sell called the Foreclosure Protection Act contract, which raises the question, when do you use the Foreclosure Protection Act contract? Do you use it anytime the property is in foreclosure? Do you use it merely because the loan is in default? Do you only use it sometimes when the property is in foreclosure? If you want to know the answers to those questions, keep watching this video. Now, those of you who've watched this far, some of you might have an awareness the Division of Real Estate has this flow chart. The Division of Real Estate has created a flow chart that addresses the scenario in which you use the Foreclosure Protection Act version of the Real Estate Commission approved contract. And so you're thinking, John, why are you recording a video on this? Why don't you just refer us to the Division of Real Estate's flow chart? Number one, I am referring you to the Division of Real Estate's flow chart. I've studied it. It's excellent. I've matched it up against the statute. It's good. It's good for a certain type of brain. The Division of Real Estate's flow chart is ambitious in the sense that it's trying to provide you a flow chart that works in all situations. I'm not trying to do that. I'm trying to give you a more intuitive solution, a more tree version of the decisions you need to go through, a more intuitive way of understanding the Foreclosure Protection Act that works in most situations. It gets you close. And the reason that's relevant is the Division of Real Estate's flow chart essentially says, okay, at the tree level, okay, go to this tree, look behind the tree. If there's a yes, you go to this direction to the next tree. If there's a no, you go this direction to that tree. Then you look on behind that tree. If there's a yes, you go this direction. If there's a no, you go over here. And it's very good for leading you around, but at the end, when you get to the answer, you don't know where you are. I want to give you a more bird's eye view. I want to give you a forest view of how the Foreclosure Protection Act works, because I think it's less likely to lead to an error. All right, what's the concept? Here's the concept. It's the Goldilocks concept. There are certain transactions that are too cold. Now with Goldilocks, if the porridge was too cold, that was bad. Goldilocks didn't want to eat the porridge that was too cold. In this analogy, too cold is good. Too cold is good. That means you do not have to use a special Foreclosure Protection Act contract to write the offer. That's the too cold zone. Then there's another zone, the just right zone. The just right zone is a zone where you can write the contract to document the deal. The contract needs to be on the Foreclosure Protection Act form. Then there's one more zone, of course. You know what it's called, the too hot zone. If you're in the too hot zone, you can't write the contract at all. All right, now you want to know what the two zones are. Let's talk about the too cold zone first. The too cold zone. If the property has no equity in it, so for example, if you're selling a property for $500,000 and it has $600,000 of debt against it, that is a property that has no equity in it. If the property has no equity in it, you are in the too cold zone. You do not need to use the Foreclosure Protection Act version of the contract. And to try and make that more intuitive, the Foreclosure Protection Act is designed to protect owners who have equity in their property. If the owner does not have equity in the property, they do not need as much protection from, the vicious predatory investors. So the Foreclosure Protection Act does not apply, and you don't need to use the Real Estate Commission's Foreclosure Protection Act version of the form. Next criteria, we're still in the too cold zone. If the owner doesn't have any equity, and all these things in the too cold zone are linked by ors, not and, or if the property is not the seller's principal residence, then you don't use the Foreclosure Protection Act. Hopefully that's intuitive. Imagine Phil Anschutz owns a skyscraper in downtown Denver that's in foreclosure. The Foreclosure Protection Act isn't designed to protect somebody like Phil Anschutz or somebody else who's an investor. Now let's pause for a second. Deciding whether a property has equity in it, it's a little gray. What if the property is worth $500,000 and the has $500,000 of debt against it? Well, when you factor in transaction costs, the seller has no net equity in the property, but it's gray. What if you don't know? At the time you're taking the listing, you think the market might pay $530,000, enough to cover perhaps the transaction costs. You don't know what the transaction costs are exactly. There's gray there. In this video, I cannot get into all the nuance of that gray. But if there's clearly no equity in the property, the Foreclosure Protection Act contract form need not be used. If the property is clearly not the seller's principal residence, you don't need to use the Foreclosure Protection Act form. Could be a lot of gray. It was the seller's principal residence, but because of layoff and job transfer, they moved to Florida, but they have intentions of moving back. Too gray, beyond the scope of this video. Next one, or if the buyer is buying the property to be their residence, if the buyer is an owner-occupant, on the theory that they're not then a predatory foreclosure investor, then the Foreclosure Protection Act does not apply to that transaction, and you do not need to use the Foreclosure Protection Act version of the contract. Another criteria, if the property is not residential, if the property is a marijuana grow operation, Foreclosure Protection Act does not apply. If the property is an office building, the Foreclosure Protection Act does not apply. If it's a strip mall, the Foreclosure Protection Act does not apply. Again, there can be gray. There is the mixed-use property. There is the property that is a bar on the first floor and a residence on the second floor. Yes, I've seen properties like that. There can be gray. Don't have the ability to go into all the depth of the gray in there. And then here's the last situation, and this one is especially gray. You also don't use the Foreclosure Protection Act contract if there's essentially no reason for the buyer to know, and the buyer doesn't know, that the loan is in default or the property is in foreclosure. If any one of those criteria are true, just to repeat, if the seller doesn't have any equity in the property, if the property is not residential, if it's not the seller's primary residence, if the buyer intends to occupy the property as an owner-occupant, or if the buyer has no awareness that the loan secured by the property or loans secured by the property in default, then the Foreclosure Protection Act does not apply. You can write the offer on the regular real estate commission approved contract. That's the too cold zone. That's good. You don't use the Foreclosure Protection Act form. You just write the offer on the real estate commission approved contract. If the seller's upside down, it might need to be special in other ways. You might need a short sale addendum, but you do not need to use the Foreclosure Protection Act contract. All right, what's the just right zone? The just right zone is the reverse of all those things. If all those things are true, and I'm going to go through them, but if all those things are true, then you need to use the Foreclosure Protection Act contract. So what does that mean? One, you use the seller has to have equity in the property. Number two, it needs to be residential property. Number three, the seller has to occupy that property as the seller's primary residence. We're not talking about the ski condo that they go up to, that they go to in Winter Park. Seller's primary residence. Number four, the buyer needs to be an investor. The buyer needs to be a non-owner occupant. The buyer needs to be an investor. And then number five, the buyer has reason to know or actually does know that there is a loan on the property that's in default. There's nuance in the statute, but for purposes of this video, the investor buyer knows that the loan is in default or has reason to know that it is in default. Now, what might that reason to know be? And it might be that there is a foreclosure commenced against the property. And when there's a foreclosure commenced against a property, there's something recorded against the property called a notice of election and demand. And that notice of election and demand, I'm going to throw some jargon at you, means that the buyer is on constructive notice that the foreclosure has been commenced. So if there's a notice of election demand recorded against the property, plus the other criteria are met, then the contract needs to be written on the Foreclosure Protection Act contract. That's the just right zone. Okay, what makes it too hot? What makes it too hot for brokers to write the offer at all? One is if it's a subject to or assumption transaction. That is, the seller's existing debt is not being paid off as part of the transaction, but the buyer is buying the property subject to the existing debt and perhaps agreeing to assume the liability under that. Another one would be if there's rent back by the owner who's being foreclosed upon. Another one would be if the owner who's being foreclosed on is selling the property but has an option to buy it back later. Another thing that makes it too hot is if the buyer, remember we're picturing this snaky, aggressive foreclosure investor buyer. If you want to put a face to that, think of me, because I was a foreclosure investor. But if the foreclosure investor has given the seller money to, for example, sign the contract, or given the seller money to get a quitclaim deed or a bargain and sale deed from the seller, if there's any consideration that's being paid from the investor buyer to the seller before closing, that's also something that disqualifies brokers from being able to write the deal. Those are the three zones. All right, that's the high level knowledge of the things. In real life, it's a little bit more complicated than the Goldilocks three zones. And even if I presented it to you, I presented to you plenty of gray. What does residential mean? What does owner occupied mean? What does it mean for the buyer to be on constructive notice of the foreclosure? Plenty of gray. But I think in a lot of situations, this will be pretty easy. If you're a broker working with a buyer who's just a regular old, I want to buy a house to live in kind of buyer, and I'm a dentist and my wife is works for the district attorney's office as an attorney, then the Foreclosure Protection Act doesn't apply. Or you're representing a buyer who's making an offer on a property, and in the MLS remarks it says it's a short sale. There's not any judgment call, because if it's a short sale, the seller doesn't have any equity. The Foreclosure Protection Act contract is not used for that transaction. All right, some of you are thinking, okay, John, you've helped us understand, thank you very much, situations in which we don't need to use the form, situations in which we must use the form, and situations where we can't write the deal. In the situations where we must use the form, how do we complete it? How do we use the other documents that are referenced in that form? Good question, but it's beyond the duration of this video. If you want to know the answer to that one, you'll have to watch our next video addressing not when to use the Foreclosure Protection Act version of the contract, it's how to use the Foreclosure Protection Act version of the contract. Catch you in the next video. Remember, we live in a complicated world. Be careful out there.